Okay, welcome everybody this morning. My name is Linda Ross. I am joined today by Callum Sinclair, and we're going to talk to you today about Brexit and commercial contracts to give you some tips about managing the transition risks to hopefully save you both time and money in the future. We are here to talk to you about commercial contracts and the risks associated with the Brexit transition period ending on the 31st of December. Now, after that time, we may have a trade deal with the EU, or we may not, but either way, there will be changes that could impact your contracts. And ultimately, that means impact your financial bottom line. Callum and I come to this topic with different interests. Callum is a contract specialist, particularly in technology contracts like IT, outsourcing and cloud agreements. And it has to be said, I do something very different. I am at heart a commercial litigator that knows nothing about IT outsourcing, but my particular focus is on the construction sector. But before we talk about commercial contracts in detail, I would like to make a preliminary point. And that is that contracts contain the terms of the agreement reached between two or more parties at a fixed point in time. Then real life stuff happens. We have pandemics, Brexit, trade deals, no trade deals, whatever. But projects and agreements do not work out as planned. Disagreements tend to follow. And that's when we blow the dust off the contract, or perhaps it's more accurate to say these days that the electronic files are searched. We find that contract, we read it to see what it actually says about the situation we find ourselves in. Now, the reality is that often there'll be no mention whatsoever in those contracts about COVID, pandemics, leaving the EU, transition periods. There'll be nothing about that. But that does not mean that the risks associated with those real life events are not addressed in your contract. It just means you need to know where to look and what to watch out for when negotiating contracts. And that's what we're going to help you with today, or at least we're going to try to. So we'll be asking two questions. The first one will be, where are the hidden risks in commercial contracts? Where are the hidden risks in commercial contracts? And then secondly, I'll ask the question, do you know your options? Then we're going to finish off with a few practical tips from each of us. Now, Callum, over to you. Now that I've explained our plan for the day, I'm going to ask you the first question, which is, where do you think the hidden risks lie in commercial contracts?
Thanks very much, Linda. Good morning, everyone. Most well-drafted commercial contracts address the issues that are concerning people by, for example, ensuring it's a fixed price contract or stating expressly who is to bear the risk of tariffs or compliance with regulations or delay. And the point I'd really like to make today is that the dangers often can lie in what is not said in a contract, or in something that is said, but it's not enough to protect the client's position against the real life events that we're currently facing. People without specialist contract law training usually focus their contract reviews on what's on the page in black and white. But in truth, what is not said on the page can have just as significant an impact as what is. So often we come across situations where senior management or personnel and finance, procurement or sales or administrative functions take the lead in preparing or negotiating commercial contracts. Or worse, they're designated as responsible for signing off on supposedly standard terms and conditions, often represented by the counterparty as being non-negotiable. And I entirely understand that these individuals may well be experts in their respective fields and that their input will be critical. But their field is not contract law, and the law of contract is very specialised with lots of hidden traps for the unwary.
Okay, so your field is contract law. So I'm going to put you on the spot and ask you for your top 3 or 4 hidden risks in commercial contracts. What do you think they would be?
Okay, well, I would say generally what we see often is not capping liability. not enhancing or restricting termination rights, and ignoring boilerplate. The other thing to bear in mind is to beware of express terms that can sound innocuous. For example, an obligation to act in good faith or in the spirit of mutual trust. These don't really add much when everyone is working well together, and they can become fertile ground on which to base disputes with unpredictable results when times are hard. Also, not having an understanding of what the common law says, even if the contract is silent, can be crucial for things like determining the scope of likely damages for contract breach. Maybe one final point at this stage, which is becoming particularly important at the moment, is not stating clearly enough what law the parties have to comply with and at what time. From the 1st of January, is that domestic law, whether Scots or English law? Is it EU law, or is it a mix of both? What happens when those laws start to go their own way, and what is the compliance baseline, and who bears the financial consequences if the parties deviate from it? To the extent possible, those are not issues that you would want to leave to chance. Contracts can bring certainty, but it's more important than ever that they are clearly drafted. Let me give you a basic, a generic commercial contract example with an overlay of Brexit transition to demonstrate what I mean. And imagine this scenario on the screen just now. So Petit, a French business, supplies 120 little widgets to Transform Limited every year, 10 to be delivered by the 30th of each month. Petit is based in France and Transform Limited in the UK. The little widgets are then incorporated by Transform Limited into bigger widgets. If the big widgets are not delivered by Transform to End Products Limited by the 15th, then End Products will incur a massive loss of £1 million a month. So Transform Limited's in a complete panic. Petit thinks that some of its widgets are likely to be delayed at ports. Petit says it's going to pay the new tariffs and increased import taxes it thinks are going to be due, and will add those to the price to Transform Limited. Petit also says it can't guarantee that the little widgets will comply with any new regulations. End Products Limited says it's going to claim £1 million a month in losses from Transform if the bigger widgets are delayed. So Transform Limited rushes to look at the two contracts. So let's start with the contract with End Products Limited. The contract is based on End Products standard terms and conditions. There's no mention of caps and liability for damages or exclusion of losses for Transform, and silence very much is not golden in those circumstances. The lack of a clause means that Transform's liability is effectively uncapped. It would have taken moments in initial contract negotiations to introduce appropriate limitations of liability for Transform. The termination provisions are one-sided. There are lots of clauses in the contract about End Products' right to terminate, and no mention of Transform's right to terminate on an agreed notice period or if supply problems should arise. The contract doesn't contain force majeure provisions, and it's unlikely that the bar would be high enough to trigger the common law of frustration. Okay, so maybe there's more solace in Transform's contract with Petit. Well, in that contract, the price is stated to be fixed. But on closer examination, there are exceptions in the small print allowing Petit to alter prices where Petit's costs of supply increase. The products are stated that they must be in compliance with applicable laws. But what does that mean? Does that mean EU law or the new UK domestic law, or some mix of the two? And the prospect of a dispute in the courts looms large, but there's no governing law or jurisdiction clause. So they'll end up in the French courts or in the Scottish courts. And Transform is understandably distraught. You get the picture.
Okay, I think I do get the picture. Distraught's probably putting up even mildly. That's got every legal problem you want to have. But if I was to try and sort of draw out the lessons from that, so if I was to take your example, the point you're making is that if Transform had appreciated the significance of all these points I've now put on a slide, then that would have made a massive difference to the position it now finds itself in. So, for example, they could have capped their liability, enhanced their termination rights, watched out for innocent looking drafting that come January has significant or unintended consequences. And then on top of that, it wouldn't have taken very much to review any references to which laws to apply and which courts are to resolve disputes. And I'll just pop in a wee plug here now for also possibly considering any alternative dispute resolution options, such as arbitration or mediation. So all of that could have put Transform in a much stronger position, which would ultimately have saved them a lot of worry, time and money in sorting all these problems out. So I think really what we're summarising this part of the talk as, is we're saying that in each case the problem wasn't so much with what was said, but what was not said, or not said clearly enough. In other words, the problems lay in what was hidden in the contract.
Yeah, that's absolutely right, Linda. And the whole point about managing risk, and I mean any risk, COVID, Brexit or otherwise, is that you don't just look at a single clause in isolation, but at the contract as a whole against a backdrop of a robust knowledge of evolving laws. Sometimes the structure and the basis of contracts will actually need to be considered too. So one example, at the moment, we're working with a client and with an existing distribution agreement covering the whole of the island of Ireland. And it's likely we'll be helping them to restructure that into a distribution agreement for the Republic of Ireland only, but with more of a sales agency arrangement in Northern Ireland, with our client supplying direct to customers as a contract party. And in doing that, we need to think about taxation, we need to think about trade credit insurance, we need to think about commercial agents rules and their continued applicability or not, and so the list goes on.
Good. Right. Well, let's move on to our second question. We've covered off the hidden risks. I hope we've made our point. And the second question was about knowing your options, because it's always good news that you've got some options. So if you were given a contract to look at now, what approach would you take to managing any transition risks that a client has identified?
Okay, so firstly, I would discuss with the client the risks that they have identified and work with them to consider whether there might be anything they perhaps haven't thought about. Then I'd explore their options for managing the risks they have identified, as shown in the slide just now. Now, the reality is that most clients are adopting either options 1 or 2 from that slide. And I know, Linda, you've seen examples of some more and less imaginative approaches to the third option. But the key point about taking the first option, which is essentially leaving the impact of the identified risks unaddressed in specific terms, is that decision must be taken on an informed basis. Just leaving alone or burying head in the sand should not be an option. And then, having decided what approach to take, I would then look at the wording in the contract. So basically, there are 2 drafting approaches that you could take that are shown on this slide here. Again, I'm not going to go into detail here, but the point is simply to demonstrate that commercial contract drafting is a carefully honed skill and something that lawyers are well accustomed to doing. So option 1 in particular, this is the kind of standalone clause, specifically dealing with a risk. That can be used, that can be a blunt instrument, and it might well be unlikely to be acceptable to a counterparty if it's dropped in from a great height. And we have seen some clumsy attempts to use this sort of approach, where basically it's we take no Brexit risk, you contract counterparty take it all. But it really all depends on the risks that the client wants to manage. What are the relative bargaining positions? What does the current contract say, if there is one? And what have the parties agreed between themselves as to whether I would draft a standalone clause or whether there would be a much more forensic examination of the contract, and whether we tighten up specific clauses or address new clauses potentially, some of which are set out on the slide.
Yeah, I think one of the issues we are facing at the moment is the known unknown. and it is a real problem. So I have seen some clients basically agreeing that if problems arise because of the lack of a trade deal with the EU, then they agree they will meet and agree what is to be done. In other words, agree to agree. Now, I have to say that's all rather woolly, which is a well-known legal term, and not a course I would generally advocate, but I do understand why they've done this, particularly if you have a good relationship with the other party or a long-term relationship, and I can see it being a practical way forward, but there has to be a word of warning with that type of approach. It's not a particularly legally enforceable one. But having said that, I think we can take a lot of positives away from how companies have responded to COVID. What do you think?
Yeah, no, I completely agree. I mean, now more than ever before, I think pragmatism and strong partner relationships will be important. Whether it's COVID or Brexit or one leading into the other, a robust understanding of contractual backstop positions remains key. But flexibility and understanding with counterparties can go a long way. And we did see that particularly in the early days of COVID, where parties were keen to examine their contracts, but that was more with a view to understanding what the backstop position was, and there was a willingness and a desire to work with contract counterparties for the most part. You do have to be careful though where you are allowing reliefs, that you're not inadvertently waiving your contractual rights to bring claims later in the day should that become necessary. So things like no oral variations and no waiver clauses in your contracts are very important here, as are your actions as a contract party.
Okay, so sticking with the question about knowing your options, I'm going to ask one last question. If someone is sitting with a contract in front of them now that they signed last year before the world turned on its head, they're now struggling to perform it, or they're facing risks in performing which are just becoming too high, what options do you think they have?
I've summarised on this slide here that what I think are your four main options in that situation. I'll just give you a second to have a look at that. I mean, I would be honest and say that the reality is that certainly as far as I'm seeing, most clients are still in the realm of option one. That is continuing to perform the contract, whether as an informed choice or not. Most organisations are still reeling from the consequences of COVID. But I do wonder if the combined consequences of both COVID and the lack of a trade deal, if that's the way it goes, whether we'll see companies being left with no option but to embrace some of those more radical options on the slide. So that is about exercising contractual options. It's about, and understanding them in the first case, it's about renegotiating or opening negotiations for amending the contract, or indeed, I suppose the nuclear option, depending on what the contract says, terminating the contract.
Okay, well, with my litigator's hat on there, I'll just exercise a word of warning about the nuclear option of terminating the contract, not one to be taken lightly. I'm going to stop sharing the presentation now, and we're now going to move on just to the final part of our session today. We're just going to finish with some top tips. So I've got 4 top tips. That's from a sort of contentious point of view. The first one is, in contract law, it does not matter what you meant to say, what you thought you said. If a contract ends up in court, then all that matters is the actual words written down on the paper. So I don't know how many times I say that, but sometimes it still seems to come as a surprise to people. It doesn't really matter what you thought those words meant, or it's actually the words on the piece of paper that matter at the end of the day. Number 2, stress test your contract. So take 10 minutes out of your day-to-day to ask, what if? What if your worst scenario happens? Is the answer about who bears the risk of that worst case scenario clear in your contract? If it's not, what am I going to do about it? Thirdly, escape routes. I think escape routes are actually hugely underestimated because when people enter into a contract, they're not actually thinking about getting out of a contract. But escape routes are a vital lifeline when things get tricky. And by that, I mean strong termination rights, break options, shorter contract periods. Because sometimes the best way to minimize your risk is to control how long you are actually exposed to it, or how quickly you can escape from it. And my fourth top tip and final one is records. I just can't emphasize this enough. Take notes, minutes, write letters, record what you're doing and why, and file everything clearly. I think we all, at the time we're making decisions, when you're having a really bad day and you can't ever imagine forgetting that day and what was said and why it was said and why decisions we're making, well, everything seems so clear. And we can't ever imagine being unable to recall the details of the horrific day we've had. But the reality is that disputes about commercial contracts often take years and years to get to the courts. Memories fade, witnesses can't be found, employees move on. But on the other hand, written records stand the test of time. So that would be my 4 top tips. Callum, what about yours?
Okay, well, I suppose where I would start is that if choppy waters do lie ahead, then it's time to raise your head above the water. I totally understand that why looking at the fine detail of contracts is not everyone's cup of tea, but it matters now more than ever. And why is that? Well, because I think we all know there are tough times ahead for the UK economy. That means reduced margins, and it also means a predicted tidal wave of insolvencies or certainly business distress. And all of that combines in practice to mean more disputes. But if the risks have been thought about in advance, if good legal advice has been taken, if contract terms have been tightly drafted, if options have been analysed, then the risk of disputes arising is much, much, much smaller. So that would be my first top tip. I would also say that my second tip would be making sure you set aside the time and the money now to reduce the anxiety and the potentially substantial costs and consequences of the future, or of failing to do that now. It's now more important than it ever has been to ensure that proper attention is given to the expert scrutiny of your commercial contracts. Yes, that does involve some time and money at the outset at a time where businesses, perhaps are struggling or legal budgets are shrinking. But businesses which make that smart investment now will be setting themselves up best for plain sailing in uncertain times ahead. Throttling the sailing analogies there, but what it really comes down to is that there is often too much of a focus on risk management and not really enough focus on value creation through a contract estate. And that would lead me to my third top tip, which would be to focus on value creation as well as risk management. Risk management is incredibly important, and the contract is a really valuable tool among many tools, insurance and so on, in managing that risk. But often clients focus on that at the expense of value creation. An expert contract lawyer with a strong commercial sector focus is a value creator for you. They will have seen similar contracts multiple times. They'll have represented both sides. They'll have presented and heard all of the arguments. And they will know where they can make you savings and drive value through the contract. Countless times, and we work very closely with our corporate finance teams, I've seen businesses in M&A transactions achieve significantly higher multiples or valuations where good legal teams have supported their contracts work over the years, or been engaged in pre-transactional diligence readiness programs to ensure that contracts are robust and clear and up to date. And I suppose at the moment, if not Brexit proof, then with very much Brexit in mind. And that goes beyond just checking the usual stuff, the change of control clauses. It's indicative of a level of care and professionalism in running the business, which engenders confidence. And if the same can be said for businesses which are raising investment or raising finance. And the reverse is also true, of course. So deals have died at the first sight of a shambolic data room or poorly drafted or onerous contracts, or it just provides the other side with an opportunity to chip away at the value. So I think to wrap up then, and from my perspective and summarise our key message today, it would be, well, maybe I should return to the title of this webinar, which I think was Commercial Contracts, Managing the Transition Risks to Save You Time and Money. And I might be tempted to recast that to say commercial contracts, spending time and money on your contracts now will save you a lot more time and money in the future in managing transition and other risks.
Okay, thanks very much, Callum. That's the end of our webinar today. Thank you all for coming along to listen. We don't have time for questions, but we are going to put up our contact details on the screen in a moment, and don't hesitate to get in touch with any feedback or questions because we would be delighted to help. So thank you all for listening.
Thanks very much indeed, everyone. Thank you.